Court is now open. You may be seated.
Morning. Thank you.
SJC-10832, Commonwealth.
All right, let's proceed. Yes, good morning.
Good morning. If it please the court. My name is Stephen Maidman, and I represent Thomas Mercado, the defendant in this case. There are two issues in the case. The first one involves a Miranda, ineffective assistance of counsel claim, and the second claim is an open courtroom claim. I would like to address the Miranda claim first, and then in my remaining time, address the open courtroom claim. To get to the heart of the issue on the Miranda issue, the evidence submitted in connection with the motion for new trial and the record testimony at the suppression hearing, I would suggest, overwhelmingly shows that this defendant was subject to custodial interrogation at a local branch.
Well, he was in prison in Puerto Rico, right?
He was in prison in Puerto Rico.
And when the officers from Massachusetts went there, they didn't take him into custody.
No.
Because he was already an inmate.
Correct.
Now, what was it that they did that made it into a custodial interrogation?
They arranged for him to be brought to the local offices of the FBI, where he was subject to what we would classically refer to as custodial interrogation.
Is there agreement on both sides that he was taken from the prison to the FBI? Part of what I read was
that's a fair. I'm not sure. There certainly is not an agreement. The Commonwealth, in their brief, has never admitted that the defendant was brought to the FBI's offices.
But Judge Connor seemed to.
He certainly thought so.
Yes.
He thought so, and in connection with the motion for new trial, the defendant submitted an affidavit from a police officer from Brockton who said he was interrogated at the FBI. He wasn't interrogated at a prison, and then the defendant submitted his own affidavit recounting how he was brought to the FBI offices. He thought he was going to court. And then finally, I obtained from the Department of Corrections in Puerto Rico a document from the defendant's file, which basically is a form. It's translated and it's in my brief, and it says he's going for other purposes somewhere from the prison. So I don't think there's any question, and Judge Connor certainly didn't seem to question that the man was brought to the FBI offices where he was interrogated.
Let me ask you this about that. Judge Ball, it appeared to me, while she did not seem to agree, or, I mean, she didn't really focus on, I mean, I think she thought, in your favor, would think that he was probably in the prison, but she did say, certainly you've got an ineffective assistance argument, and it seemed to me that motion counsel was, for your client, was arguing, no, he wasn't in the prison, he was at this office, and she ultimately said, I don't think it's going to make any difference. So I'm trying to see where the ineffectiveness is there.
Well, the ineffectiveness was he could have developed that factual record. He could have done the same things I did. He could have. But
it wasn't going to make any difference to her.
Well, if one looks at the Larkin case and one looks at the the Supreme Court did not decide the Fields versus Howe case until 2012, but they're essentially the same. When you look at I was rather struck by the fact that the SJC decision was very consistent with Fields versus Howe, and that goes into great detail about the fact that just being incarcerated in prison does not equal Miranda custody, but there are all the other factors which certainly would qualify, at least in this particular case, that the defendant was subject to custody within the meaning of Miranda.
Are you saying that Judge Ball was not made aware of those factors?
Oh, she was not made aware of those factors.
As to the FBI offices, or the differences between the conditions at the prison in which he was held versus the conditions at the FBI? Was she made aware of these differences?
Was she made aware of these differences? No, because they were never brought out by the defendant's lawyer.
So is that where you're claiming the ineffectiveness lies?
Yes. He certainly did not develop the record. The record would suggest that he was unaware of the Larkin case, at least at the hearing where he was supposed to develop the factual record.
So he had nothing about he was in handcuffs and leg cuffs and things like that?
Actually, that was the one thing that was in there, because it came out that supposedly in the prison he was in handcuffs and leg cuffs. But it turns out he was in handcuffs and leg cuffs over at the FBI offices as well. It really was not developed. There was not one. I don't think the defendant's lawyer asked one question about the location of the interrogation. And what you'll see is the defendant's affidavit basically tracks all the various Fields versus Howe Larkin factors about what happened. And, taken together, aside from the fact that, I mean, Judge Walker he said being brought to FBI headquarters and being questioned about a murder in Massachusetts amounted to creating a custodial setting. And I just
Connor?
That was Judge. Wrong judge. Judge Connor.
Okay, I was trying
No,
to.
you're
Is there a
absolutely
third
right.
judge in here?
I have
couldn't-
other cases with Judge Walker. Judge Connor.
So what's the overall prejudice here? This statement, which really wasn't much, was admitted to show consciousness of guilt.
Yes.
But of course, your client had fled to Puerto Rico when it was using an alias. All of that was also evidence of consciousness of guilt.
That at the trial that he had fled to Puerto Rico, I don't believe it didn't come in exactly that way. There was a lot of discussion on the record about what would come in terms of consciousness of guilt evidence. But the Commonwealth certainly wanted that in, and you have to set the stage of how this was used. You had the Commonwealth used all the precipient witnesses were immunized witnesses, and to use the phrase from Judge Connor, they were either drug dealers, addicts, or prostitutes. These were the Commonwealth. These witnesses had a lot of baggage. I mean, by any definition, they were all immunized, which gets to the second issue. So and then the defendant testified. He says, "I was at the apartment, but then I left." So it amounted to a credibility contest. And a rational juror looking at this could say, I don't believe any of these people. And we're dealing with reasonable doubt here.
Yes, but there was evidence that he was using an alias.
There was evidence that there certainly was available evidence that he was using an alias. I don't believe that.
There was evidence at trial, was there not?
That's not the way it came in. The evidence at trial was, because it was admitted, it was his incriminating statement. He denied he was Thomas Mercado.
Well, the Commonwealth.
I believe that. I mean, I could be wrong about that, but I'm pretty sure I'm right. It was the fact that he denied. He said he was Ariel. He was another person.
When he was in Puerto Rico and speaking to the police.
Yes.
Now, but I take that the Commonwealth's brief suggests that there was other evidence. Were you making the point that it was available? It could have been put before the jury, but I take it was not put before the jury?
I don't.
Only this police evidence that was put before the jury?
I think so. They were very careful about that to limit that kind of evidence, and there are discussions in the record about that.
But I mean, it was because this was admitted that the other available evidence was not.
I think.
But there's no question, but that there was other evidence that could have been put in.
There was other evidence. Now, would it get into evidence? Was it hearsay? How would they brought about it? How would they have gotten it into evidence? I mean, lots of issues involving that. They would have had it's just an example of, well, if the incriminating statements had been inadmissible, the Commonwealth would have done X, Y, and Z, and the defendant probably would have done something as well. Mm-hmm. So, the Commonwealth does make that point. Well, we could have gotten we could have brought in the jailers and said he's Ariel Rivera, that kind of thing. I mean, sure, they could have flown all sorts of people in, but the point is they didn't.
Can I ask you this? I'm not quite sure. Are you challenging both the ineffectiveness of counsel in connection with this motion to suppress and the merits of the decision as well?
the merits of Judge Ball's decision?
Yes.
Well, I'm certainly raising the ineffective assistance of the counsel claim and arguing that under both prongs of Safarian or Strickland that, number one, it was unreasonable attorney performance not to do these things, and number two, he was prejudiced by it.
But if it wouldn't have made a difference
It would have made
to Judge Ball's decision, if Judge Ball's decision is correct,
that's fair. Her decision is wrong. Her decision is wrong, because she did not have an adequate record in which to make a decision.
But she could have been right for the wrong reason, couldn't she?
I think she was wrong for the right reasons, wrong for the wrong reasons, quite frankly. She was not aware of. She had the same reaction that most people have. That, the guy's in prison. He's got to be in custody. That was the reaction she had at the hearing. That was a perfectly. You put 50 lawyers in a room, they'll give you the same reaction. But the fact is that it did make a difference in this case. If you look at each of the Larkin, all the factors they talk about in Larkin and they talk about in the Supreme Court's decision, it's wrong. I mean, the statement should have been suppressed.
but she had the Larkin case essentially in front of her, didn't she? I mean, they talked.
Yeah, she pulled it off. Literally, she pulled it out. Yes.
I mean, at the end of the first day,
Right.
the Larkin case was raised, and then
Right.
the next day there was argument
Right.
specifically on the Larkin case.
Yes. But like, as I stated, she didn't have an adequate factual record because the lawyer never developed the factual record. And I don't think, at least in terms of the quality of representation. Let me make one point. The lawyer in this case was not a bad lawyer. But ineffective assistance of counsel is very fact-specific, and it's very idiosyncratic to the extent that it's what he did in respect to the motion to suppress that he was constitutionally incompetent. I mean, the fact that he could walk in and into the case involving a guy who is in prison, and it's a Miranda issue, and not have read the Larkin case, and the judge is
You don't know that, do you?
one can certainly infer that from the record.
Well, particularly when Judge Ball has it in front of her, and he's saying, does he say, I haven't read this case?
Well, look here. Listen, Judge Ball goes, I think Mr. Galliboy ought to have the opportunity to look at the case law. Then she goes, then he goes, I'll certainly be getting my own copies, Judge. And then Judge Ball goes, I think you should have an opportunity to shepherdize it. I mean, one can infer that he was not prepared for this hearing.
Right. That was the end of the first day.
Yeah. Unless there are any further questions, I'll move on to the second issue in my remaining time. Closed courtrooms. There are many cases in Massachusetts at the present time involving closed courtrooms. This one is unusual for a couple of reasons. This is not a situation where there's any claim that by the there's certainly no arguable claim that there was an express waiver. In other words, the defendant got up and said, I waived my right to a public trial.
This is an immunity hearing, right?
It's an immunity hearing.
Don't we have
We do. You're absolutely right. We have the statute.
not just the statute, there's case law about how this is supposed to be a closed hearing without the Commonwealth there, I thought. I mean, without the...
I don't recall case law. We have a statute. And the statute is a 1970 statute, pre-Waller. And it's also pre the statute in the Globe newspaper case involving trials involving rape and incest victims, where the parties can agree to exclude the public. And this happened on the first day of the defendant's trial. And prior to that, there were perhaps 4 other immunity hearings, which, at least based on the record, were open to the public. But this was the first day of trial, so the defendant's there, and so the prosecutor goes, let's clear the court, Judge, clear the courtroom. And the judge announces, clear the courtroom. And so out the door goes the defendant, out the door goes the defendant's lawyer. No objection. And the defendant did not have the get into, is it structural error? Is it okay? Well, how is the defendant been hurt? Unlike all the other cases, the Lavoie case, the Dyer case, in those cases, the defendant's there. He at least gets to see what happens in the courtroom. This case, he's booted out the door without an objection. And this was not in the ancient days of closed courtrooms. This is a 2009 trial. The Cohn case was decided in 2010.
Are these kinds of immunity hearings, though, part of the trial? Or are they separate proceedings?
This one was the day of the trial.
Well, it may have been the same day, but I mean, sometimes, in courtrooms, judges do more than one thing.
Yes.
They often happen before trial.
The others did happen before trial. But the right to a public trial extends to ancillary proceedings. It would extend to a motion to suppress hearing.
But that concerns this.
This is not something that concerns this defendant. This is a witness the Commonwealth is seeking immunity for. This is not connected really to the defendant.
Well, that is the Commonwealth's claim. That the defendant has no right, no interest in whether the defendant is granted immunity. On the other hand, the public, and I would add that the First Amendment rights to a public trial are coextensive with the Sixth Amendment rights.
But I don't think that the defendant is in a position to assert the First Amendment rights of other people.
I don't know the answer to that. I know there has been, if you look at the Presley case and the Waller case, and some of the other recent cases involving news media, that I'm not sure whether that is
The case I'm thinking of, Mr. Maidman, is Commonwealth versus Pixley. Is that?
I don't know. I know I'm familiar. I know there's the Pixley case. I just don't know.
It's a case about immunity, and I thought that we said. Maybe you would say it's not correct, but I think that we said that this is really between the Commonwealth and the witness, and the defendant is not part of it.
Well, I just don't remember. But I would suggest that this statute, if it's not unconstitutional on its face, it's as applied is unconstitutional. What is the compelling government interest to close the courtroom?
Well, it's the interest of the witness. I mean, the witness is asserting a Fifth Amendment right. There are facts about that.
But it's not to the extent it's not the. I mean, looking at the other immunity hearings, it was more along the lines of.
Was your client there? Was your client there? I doubt
it's not in the record.
I doubt it.
I doubt it, quite frankly.
I think
it's not
what
in the
Pixley
record.
says is that you don't even necessarily get a copy of the transcript.
I did not. I did get the transcript on the earlier ones. I did not get the transcript on the one where he got booted. But in any event, I would suggest to the court that the defendant had a right to be there. The public had a right to be there. He certainly, if I were the defendant's lawyer, I certainly would have objected vehemently. And more than that, I would have liked to have seen this witness. I would have liked to have seen this immunized witness as a preview of his testimony, at least just to see what he looks like. So I think I would suggest to the court that the defendant had a right to be there. His lawyer was, to the extent that it's anything beyond a Waller claim, if it's an ineffective assistance of counsel claim, that he was did not perform as a reasonable attorney would do in Massachusetts, and that he was prejudiced. But more, I mean, the other one last point. I would suggest that Waller applies to this, and the fact that there's a group of Waller factors. If the judge had said, I look at factor 1, 2, and 3, and 4, and the factors are in my brief, and had made the ruling based on this, I close the courtroom, I think that would have been the end of it. But that didn't happen here. And I would suggest to the court that the statute itself is if it's not unconstitutional on its face, at least as it was applied in this particular situation, it violated the defendant's Sixth Amendment rights. And unless the court has any questions, I rest on my brief.
Thank you, counsel.
May it please the court, Carolyn Burbine for the Commonwealth. It's the Commonwealth's position that the trial judge properly denied the defendant's motion for a new trial based on the ineffective claim. It's our position that Judge Connor was correct that the defendant didn't satisfy either prong of Safarian.
Was there any evidence other than this evidence that the defendant was using an alias?
There were discussions of motions in limine in which the prosecution sought to admit evidence of the defendant's incarceration. And the prosecutor represented that he had a fingerprint person present to match the federal records with the Puerto Rico records. And that would be used to address the consciousness of guilt issue. And that's in transcript 1, pages 8 to 9.
That's a motion to eliminate. Did that actually come into evidence?
It did not, because then there was a negotiation among the parties where how do you want to, is there another way to get it in without the mention of jail? The judge was hesitant to reference jail. But we certainly, had we not prevailed on the motion to suppress, we certainly would have pursued this at trial. We had it available to us. We had those records, and we also had the police officer who testified that he'd gone down to Puerto Rico and met with him.
Do you think you have this, do you agree, I mean, it seems that you should agree that the defendant was not in the prison. He was actually in the FBI office, right?
Judge Connor made that finding. When you look at the testimony, however, that Judge Ball was presented with, I don't think that was made clear.
That's exactly the defendant's
and
argument.
I understand that. But Judge Ball, the big point is that Judge Ball did consider the possibility, anyway, at the defendant's insistence, that the questioning could have taken place at the FBI, and she had a discussion with defense counsel about that. She basically said, what would be the difference? So she was aware of it. She looked at Larkin. While she ultimately found that the questioning was at the prison, she discussed it. She was aware of it. She did not ignore it. And then our position is the same as Judge Connor's. The defendant had the burden of showing that his motion to suppress is likely to be successful, and he had to prove custody beyond that.
Well, let's talk about that, though.
Right. So beyond what's normally
what Mr. Maidman says is that in the prison he could walk around. He was not wearing handcuffs and leg cuffs. He had freedom of movement. Here he is driven with handcuffs and leg cuffs to an FBI office. He's sat down. They don't take them off. He's there for quite a while.
Right, and then that's where
isolated in that room, away from the prison.
Correct.
So,
well, I would ask the court to look at Commonwealth v. Smith, which discusses the totality of the circumstances.
But I guess the question is, was Judge Ball aware of all of those things?
Defense counsel was very insistent.
No, I know about he was insistent about the fact that it was at the FBI.
Yes.
And not at the prison.
Right.
But the question is, as Justice Botsford was suggesting, that there are all these other differences in the conditions of his confinement at the FBI. And that's what I'm asking is,
Yes,
was
she was
Justice Ball aware of those things?
She was aware of the handcuffs and the wrist cuffs. She was aware that he was in an office. Now, there was, as Judge Connor found, there was disagreement over where this office was, but there's no disagreement that she knew it was an office setting.
And that was very different than what had happened at the prison.
Well, it's our position that office setting in the prison is really no different from office setting at the FBI office. What would have to be shown in terms of the handcuffs, wrist cuffs, restraint is that he was subject to greater restraint by being brought to the FBI office than he would have been had it been the office at the prison, as Judge Ball believed. It is our position, no, but the defendant has the burden, and he has not established that had he been taken from his cell to an office in the prison, he also would not have been in wrist or handcuffs. So what you have to look at is the degree of the totality of the circumstances, what a reasonable person in his shoes would have believed. was this overwhelming sense that if I don't tell them what they want, I'll never, be able to leave, which is
Presumably,
Miranda.
this defendant knew that he wasn't in the prison. He looked around. He said in his affidavit that he thought he was going to a courtroom. He was very surprised. Now he wonders, who are these people? Where am I? And how am I going to get back to the prison where he is incarcerated?
Right,
yes, but has relative freedom and
But again,
protections, expectations that he doesn't have when he's sitting in this place he doesn't know where he is.
But you look at the totality of circumstances, not just that one factor. And again, he hasn't shown that had he been being taken to court, actually he thought he was being taken to court. He didn't say he thought it was strange to be put in cuffs at all to go to court. If he was taken to the infirmary, if he was taken to another part of the prison, he hasn't shown, and he has the burden, that he wouldn't have been so handcuffed. And then we look at the setting. It's an office.
Transport is different from once you get there.
I understand that, but he's not really complaining about the transport. It's the having trouble vocalizing this. It's how restrained was he? It's what was the setting? He doesn't say that they were aggressive with him, that they threatened him at all. They were overbearing. They were bullying. It's different. They're questioning about it, and they have no control over his condition in the prison. If he doesn't answer their questions, his term doesn't get extended. He doesn't get any kind of punishment via the prison. He says he couldn't have terminated the interview, but then when you look at his affidavit right after that, he says, I asked him, why my lawyer wasn't present and the interview ended. So you have to take it all into account, not just the restraints. And he has the burden to show that had it been it's unlikely they would have questioned him he doesn't say that they would have questioned him in his cell. So he would have likely been brought to an office or another location of the prison, and there's no indication that this FBI office was any more restrictive.
Let's assume for a moment that we agree with you that counsel wasn't ineffective, but we conclude that the judge's decision based on Larkin was wrong. What do we do?
Well, the bottom line is going to be there was a substantial likelihood of a miscarriage of justice.
Is that the right standard?
I believe it is.
But where a motion to suppress was filed and denied, you think a substantial risk is, or substantial likelihood?
This is a motion for a new trial. It's an appeal from a motion for a new trial on a claim of ineffective assistance.
Well, the direct
in
appeal,
combination with the direct appeal. So I believe it's all substantial likelihood of a miscarriage of justice. And I know I cited a case in my brief for that.
Is it the Commonwealth versus Wright standard?
That's not the one I cited, but
Okay. That's okay. It's in your brief.
it's in my brief at the inception of this issue.
It's not a sort of a preserved error standard.
I believe it's substantial likelihood of miscarriage of justice. And
So why isn't there a substantial likelihood of
well,
a
as
miscarriage
Judge
of
Coniff
justice here?
properly found, all this got us was consciousness of guilt.
Well,
And
Mr. Maidman says in a case where it's a credibility contest with immunized witnesses deeply involved in criminal activities versus the defendant's word, little things can matter.
well,
And the Commonwealth really wanted this into evidence, obviously.
Right, but as Judge Connor properly ruled, there was overwhelming evidence of the defendant's guilt from the witnesses on the scene. We had Ms. Cripps, who'd known him for years, and the defendant confirmed this when he testified. She identified him as the person standing in the hallway, and she identified him in a photo array. Ms. Martinez also knew the defendant. She identified him as the man she saw shooting the gun through her peephole, and she identified him from a photo array. And the victim's brother, Michael Gomes, identified him in court as the man he saw in the hallway. So we had very strong evidence.
Witnesses, all of whom were immunized and compelled to testify?
Yes, but they all testified. The Ms. Cripps and Ms. Martinez testified to their drug use and that they were not affected by that at the time that they witnessed the murder.
Well, their
et cetera.
evidence could have
So-
been very compelling if everyone believed them.
Right.
But, as Justice Cordy was suggesting, whether or not they also thought that the defendant was a liar may have factored into their credibility calculus.
But the jury also got the instruction on immunized witnesses and all that, and that's for the jury to decide who's credible. And we also had the opportunity to put that fingerprint person on had we not prevailed at the motion to suppress, so we still would have gotten the consciousness of guilt evidence in at trial.
The defense was alibi? I mean, he was somewhere else, is that right?
The defendant actually testified that he was not the person who fired the shots.
Did he testify that he was there?
I believe he did. I'd have to
Oh,
check.
no, I really don't know. I thought I had
Have
read
to-
that he said he was somewhere else, but I could be totally misremembering.
I can't remember now. If
There
you
and
said-
left.
I'm sorry.
He was there and left?
Yes, that sounds right. And then, did the court have any more questions on that issue, or should I address the immunity? On the immunity issue, it's our position that pursuant to the statute, the hearing is not supposed to be open to the public. According to Commonwealth versus Figueroa, the statutory procedure of immunity is designed to accommodate the witness's rights and the state's need for evidence. It's not addressed to the interests of the defendant. And I would point out that this was, while this took place on at the beginning of trial, we had done a separate proceeding for the other immunized witnesses. This was the only person left that hadn't been
So the
immunized.
question is whether, if it's done directly, either in the middle of the trial or in connection with the start of the trial, whether that changes the public nature of the proceeding.
And I would argue not, that it's not the defendant's, it's not for the defendant's benefit, it's for the witnesses and the state's benefit. It's, the defendant has no rights in it, and I believe that in Smith v. Commonwealth, it says that the defendant has no standing to challenge a grant of immunity. So I would argue, and I'd also like to point out, there is a transcript of that separate proceeding. It's dated June 19th, 2009. I believe the judge was Judge Locke, and it says right in the body of it that the defendant and his attorney were not present.
Do you, I don't think you cite it, but do you know the Pixley case?
I do not.
Martin case.
No, I cited Smith v. Commonwealth about no standing to challenge a grant of immunity. And I also cited Figueroa for it, that it's the witnesses' rights and the state's rights that are the main concern. While in a criminal trial, the defendant's public right, yes, that's the defendant's interests that are prevailing. But here, it's the witness's right against self-incrimination. Did the court have any further questions?
Thank you, Counsel.
Thank you.